Welcome, everyone. We'll just give people a minute or two to join us. Welcome, everyone. Thanks for being here. We'll just wait another minute to start while people are joining us. All right, welcome, everybody. I think we'll go ahead and get started. Thank you so much for joining us for this webinar. We really appreciate you being here. For those who don't know me, I'm Jennifer Mnookin, and I'm the Dean here at UCLA Law School. And I'm just delighted that you're able to join us for this second conversation in our UCLA Law School summer series on the front lines. We're very excited about this summer series of online panel discussions in which we draw on our absolutely terrific faculty and alums to address the social, legal, and political issues that are at the heart of these challenging and troubling times in our nation. And so thank you so very much for joining us for this one. And for those who are listening who are alums and involved with the school, I want to thank you too for being here and for staying connected to UCLA Law. For those of you who don't have any connection to us, thank you for being here too. We're delighted to have you. Today's conversation is entitled Racial Inequality and Policing. What's the law got to do with it? And today's conversation is presented in partnership with our Promise Institute for Human Rights here at UCLA Law School. The Promise Institute has one of its foci about race and human rights. And we're also the home at UCLA to a critical race studies program, the first in the country, to really make critical race studies an anchor and a focus of what we do at the law school. Now, needless to say, today's topic is extremely timely and important. And so I'm really delighted that we have an exceptional group of faculty panelists to have a conversation today. It's my tremendous honor to get to introduce each of these panelists, and I'm going to do this very briefly and not in the detail that any of them deserves. But I'll begin by introducing Professor Tendayi Achiume. Tendayi joined UCLA Law School in 2014, and she's an expert in international human rights law. She's also served as the faculty director of the Promise Institute. And she serves currently as the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. And Tendayi actually got that appointment to the UN even before she got tenure here at UCLA Law School, which is just kind of amazing. An additional point of pride, Professor Achiume just won UCLA's Distinguished Teaching Award, our highest faculty honor. In fact, all three of today's panelists are winners of the UCLA's Distinguished Teaching Award, and that's quite exceptional. This is not like Lake Wobegon where everybody's above average or whatever. This is it's UCLA's as a university's highest honor, and all three of the speakers today have received it because they're really truly exceptional in the classroom. That brings me to our next panelist, Devon Carbado, who is the Honorable Harry Pragerson Professor of Law. Devon joined UCLA Law School in 1997 and is one of the nation's leading scholars in critical race theory, criminal procedure, implicit bias, and many other aspects of this pertinent area of law. And he also, until recently, served as UCLA's Associate Vice Chancellor of Bruin X for Equity, Diversity, and Inclusion. And he's the author of numerous articles and books. And then finally, I'm very pleased to introduce Professor Joanna Schwartz. She joined the law school in 2006 and is one of the country's top experts on police misconduct, police qualified immunity, which we'll certainly talk about today as well. In the wake of the police killings of George Floyd and others, Joanna has been a go-to legal expert for media outlets nationwide and is leading a push for congressional legislation to hold police more accountable. So I'm thrilled to have such a distinguished group of panelists today to discuss these absolutely critical issues around policing and race. And so with that, let's go ahead and get started. And again, thank you very much for being with us. I'd like to begin by putting a question to each of the panelists, which is really about to invite each of you to speak a little bit to the way that your scholarly identity and your intellectual identity speaks to this moment in particular. Obviously, we've seen in recent weeks and the last month or so a tremendous uprising and an enormous focus on these issues of policing and police violence, as well as racism and structural racism and anti-Blackness. But of course, none of this is exactly new. And all three of you have been deeply engaged in thinking about connected issues for a very substantial period of time. And so I'd love to, Devon, let's start with you. I'd love to invite you to reflect a little bit on the relationship between your scholarly identity and intellectual identity and this moment.
So thank you, Jennifer, for that very kind and generous introduction. I'm tempted to ask you all to do what I used to ask my kids to do when they were young, which is just pretend that all of that is real. So I'm delighted to have the opportunity to engage you all. I can't see you, but again, it's terrific to have you in the Zoom room. And the question of scholarship and its relationship to the moment, I think, is an important one. One strand of my work that I have tried to pursue with some deep interest has to do with how the law articulates and conceptualizes discrimination. And this, I think, lawyers in particular understand as an important issue on the view that how we frame a social problem structures and determines how we think about solutions. So lawyers in particular understand that how you articulate the question presented is a big deal. To the extent that we have an impoverished understanding of discrimination, for example, we're likely to have an impoverished set of proffered solutions. So my investment has largely been in trying to articulate structural approaches to racial inequality. So if we think about what that means in the context of law, the dominant way of thinking about discrimination in the context of law looks crudely something like this. There's an individual bad person who engages in intentionally motivated individual acts of discrimination against some other individual person. So it's I times I times I times I. In other words, it's individualized all the way down. And that particular frame, I think you all understand, is at play in the context of policing as well. That is to say, much of our discourse focuses on looking for bad apple cops. Sometimes that gets articulated slightly differently. To what extent are some officers, most officers, all officers racist? And what I want to suggest is that that is not a particularly productive frame for managing the moment. So what I'll do in the remainder of my time in this moment is just offer a quick structural framework that gives you a sense of why it might be important to transcend the bad apple frame. So one cluster of concerns that we should have in mind is the police contact cluster. That is to say, what social forces put African Americans, for example, in contact with the police? That's a crucial question precisely because if you're outside of the zone of police contact, you're outside of the zone of possibility of violence. So to the extent that we can manage the police contact problem, that clearly diminishes the exposure a particular group has to police violence. And there are a number of important variables here, including huge factors like racial segregation, which concentrates policing in particular areas on the view that there's always already a perceived need for aggressive law enforcement presence. The broader point is that police contact is one structure that we need to keep in mind. Another huge cluster simply has to do with police self-governance. So police culture, police unions, police trainings. We could spend days just talking about police unions. The basic idea, of course, is to the extent that police unions are more interested in protecting police officers rather than holding them accountable, violence is what you will see. If police culture encourages violence, even implicitly, that's what you see. Again, that's not fundamentally about individual bad cops. The final cluster that I want to think about before shutting up is really this. So stipulate that there's been an act of violence. So some officer has engaged in an act of violence. There's no dispute about that at all. How does that act of violence interact with the legal system? Well, there are a number of answers that one might posit to that particular question. One is police violence plus the legal system equals justifiable force. And think about the different ways in which we could unpack that particular answer. A prosecutor might decide not to bring charges. That's a justifiable force moment. Or the prosecutor brings charges, but the grand jury refuses to indict. That's a reasonable force moment. Or prosecutor brings charges, grand jury refuses to, grand jury indicts, and the trier of fact concludes that the use of force is reasonable. Those are all moments in which you have police violence plus the legal system, and what you get is justifiable force. Another moment in that calculus is police violence plus the legal system equal qualified immunity. We have an expert on that particular question, so I won't say more about that. And indeed, if I go into the qualified immunity hole, you'll be saying, come back, Devon, come back, and I won't be able to come back. So I won't speak to it. Joanna Schwartz will, but that's a problem. And there's a tremendous amount of consensus that descriptively, qualified immunity makes it difficult to hold police officers accountable. Some think that's good, some think that's bad, but I think that's a descriptively accurate claim. The final thing I will say about police violence plus the legal system is this. Try holding a police department liable for the act of violence in which individual officers engage. Enormously difficult. A department would have to have an express policy or something that basically says, go attack Black people. I mean, that would not simply be a racist department, it would be a stupid one. So you're not gonna see that kind of smoking gun evidence. The short of what I'm saying is that these clusters, the police violence plus the legal system problem, the police self-governance problem, the police contact problem, has nothing to do with the individual officer engaging individual acts of violence against individual people. So we need to have a structural frame descriptively in order to think about interventionary possibilities.
Thank you, Devon. Thanks for giving us a variety of frames to help us begin to understand the structural dimensions and the critical recognition of that in any analysis of the problem. I'd love to take that opportunity and to turn to you, Joanna, and to ask the same question about your scholarly identity and intellectual identity and links to this moment and this set of challenges and possibilities.
Wonderful, and thank you. I also want to share my thanks for the generous introduction and appreciation for everyone who is tuning in today, as well as for the fellow panelists and this great opportunity to talk with each other about these important ideas. And I'm sure that we will move in the hour towards more discussion. I want to say at the outset, I think that Devon has just done a really fabulous job of explaining the tension between sort of a thought about or a focus on individual liability and broader structural concerns. And I wholeheartedly endorse the way in which he's teed up some of those problems. But I wanted to say a little bit about what my research has been and the way in which it's been engaged in this troubling, horrifying moment, but also moment of I think some great opportunity. So my research over the past 10 years or so has been focused on empirically examining the dynamics of civil rights litigation, and particularly police misconduct litigation. And I've gotten interested in this because, in significant part, because the Supreme Court, although they have sort of given or authorized the right for people to sue police and other government actors for constitutional violations, have also expressed great fear and concern about the effects of these cases, that they will over-deter officers, threaten officers with bankruptcy or financial liability, that there are a lot of frivolous cases filed, and that there's lots of need for protection against those ill effects of civil rights litigation. And my research has really focused on examining those justifications that the Supreme Court has offered for limiting the right to sue and limiting the rights to relief. And that's involved me looking in part at what's happening in courthouses, the frequency with which cases are, or the frequency with which qualified immunity doctrine is impacting lawsuits, the ways in which it's impacting lawsuits. And it's also caused me to do a lot of research and digging about things that are happening far outside the courtroom, far outside of what we think of as the law, toward things like indemnification agreements, agreements that cities enter into to agree to pay the defense costs and settlements and judgments against law enforcement officers, and the ways in which cities budget for and pay those police misconduct suits, and the extent to which local governments and police departments are gathering and analyzing information from lawsuits brought against them that they might use in order to figure out how to prevent similar incidents from happening in the future. And so my research has really been focusing on both what's happening in the courtroom and what's happening in other bureaucratic structures, and how those two aspects of the law writ large impact the deterrent effects of civil rights litigation and also implicate the Supreme Court's justifications for doctrines like qualified immunity. And I've been writing articles and thinking about qualified immunity for several years. So, you know, when some presidential candidates last year started talking about qualified immunity, I was shocked that anyone, you know, knew what those two words meant besides me. And then, you know, to be 6 months later and to have protesters on the street carrying signs saying "End qualified immunity," and have bills introduced in Congress saying the same thing has been quite remarkable. I've certainly been involved in the advocacy side, working with Congress people and their staffs to think through some of the potential impacts of eliminating qualified immunity. And I've also been working with some of those same entities in thinking about the non-legal aspects as well. Budgeting, you know, thinking about where the money should come from to resolve these cases, and what impact there should be on police departments and individual officers. And so, you know, it's been a very exciting moment at which to try to be involved in that aspect of debate and discussion for reform.
And you did a couple of years ago. You would probably not have imagined that, you know, there would be people holding up signs involving qualified immunity as such a talking point about one possible reform in this moment. Tendayi, I want to turn to you and ask the same question about your your scholarly identity and intellectual identity, and the numerous ways that it speaks to this moment. What would you like to share?
Thanks, Jennifer, for the generous introduction, and also thank you to my co-panelists for being such eloquent experts. So as Jennifer mentioned, I focus on the international human rights regime, and my work focuses on the global governance of racism and just the anti-racism framework that exists. And in my intellectual universe, theory and practice go very much hand in hand. And so my academic research, my clinical practice, and then my work with the United Nations, which involves just being an independent expert that provides the UN with advice and guidance on how states might fulfill their international human rights obligations. There's very much a symbiosis among the three hats, and I'll talk a little bit about how some of the work that I've been doing in that context applies to the current moment. So Devon was talking about his work and kind of a structural way of thinking about the challenges that we are discussing in this moment. And one of the things that's that's really exciting, and I think often not fully grappled with by legal scholars, is that the international human rights framework, especially the anti-racism one, actually provides the foundation for a structural approach to thinking about undoing structures of systemic racism. And this moment has been one where the urgency of such an approach has really been at the forefront of national and global debates. So in that context, I want to describe some of the work that I've been doing. Around the time that George Floyd was murdered and there was the national uprising, one of the things that independent experts within the UN system, myself included, began doing was trying to make sure that we were documenting and naming the violations that were taking place in this country as human rights violations, right? Especially in areas or with respect to issues where the legal frameworks, the domestic legal frameworks, were part of the issue. And this has been one of the pushes that I think we've been hearing by people who are out on the street, is that part of the problem with racial discrimination and systemic racism in law enforcement is that many of the practices that are forcing these conversations are lawful under domestic law, but they are absolutely unlawful vis-a-vis international human rights law. So an urgent area of work has just been naming a lot of the circumstances, actually violations of existing international human rights obligations that the United States actually has. So this is not some kind of future universe where the US would have to ratify the respective treaties. It is bound by them today, and there is a gap there that needs to be closed. So, for example, I led a statement that was joined by 47 other independent experts within the human rights system, calling out the abuses, and also calling out the abuses with, the abuses with respect to the response to the protests, so the militarized response that we saw from the administration. All of these concerns were being monitored and named at the international level in ways that I think were really important and new in some ways. The goal of naming violations is about pushing for accountability at the end of the day, and that's been also another aspect of the work that I've been involved in this period, which is trying to push for international accountability and trying to work in tandem with groups nationally that we're trying to push for accountability for violations. And so in June, the United Nations Human Rights Council, which is the human rights body of the UN, actually held an urgent debate on the situation in the US and on systemic racism in the law enforcement context as well. And that was remarkable. It was an opportunity for the world's nations to come together and really confront what it might mean to take seriously systemic racism in the law enforcement context. In the United States, you know, a liberal democracy that in some ways I think has branded itself exceptionally kind of perfect in the human rights realm, but is in a moment of having to confront the falsehoods around that exceptionalization of those sorts of stories. As we go on, I'll talk about the successes and the failures that we've experienced at the international level in terms of trying to hold US actors accountable. But what I do want to highlight is in my academic work, and then now in this moment, I've focused on the ways in which closing the gap between existing international human rights standards and domestic standards could actually be a really valuable resource to domestic advocates who are trying to shift law enforcement, you know, whether it's at the legislative level, whether it's in litigation. And I think this is an area that hopefully will be one that is explored more fully in litigation and lawmaking, and even in the ways that we think and talk and teach about policing. You know, I think there's a neglect of the international system when it's actually one that offers resources that are untapped.
Thank you very much. One quick comment. A few of you have already begun to ask some questions on the Q&A. Please feel free to do that. I'm going to ask our panelists a couple more questions, and then I'm going to turn to the questions that you're asking. So please feel free to, on the Q&A or in the chat, to ask your questions. And you know, there's more than 400 of you with us right now, so we probably won't get to all of them, but we'll certainly try to get to some. But Tendayi, I want to come back to you. You said we'd get a chance to hear about some of the successes and places where it didn't work, to try to create spaces for beginning to create that accountability at the international level. Could you tell us a little more about that?
Absolutely. So, you know, one of the things I think that we have been hearing, you know, from protesters and also from commentators such as Devon and Joanna as well, is that there is a problem with thinking about reform along the terms that we have previously thought about policing reform, right? The problem is a lot deeper, and the regular or typical ways of thinking about how you might solve the problem are just not working. And so in that vein, one of the pushes that independent experts, including myself, and civil society actors, social movements, one of the pushes they've been making at the UN is, how can we use the human rights framework to better dismantle and reform structures that have been structures of systemic racism. And one concrete way this demand crystallized was pushing for an international commission of inquiry into the United States. And so in the urgent debate that I mentioned earlier, there was a resolution before the Human Rights Council that would have, if it had passed, actually initiated a process that would have allowed a body of independent international human rights experts to work with national and local authorities in the US to produce a report that would name the violations and hopefully also provide a pathway to what accountability might look like. And there was a moment of hopefulness. I mean, I can't even tell you how unimaginable an urgent debate at the UN on this topic was before it happened. It's sort of how unimaginable the abolish qualified immunity at a protest, that kind of sign. The way you were saying, Joanna, that was inconceivable. This was even more inconceivable that we would even get the urgent debate. But we got the urgent debate, and we even saw a draft of a resolution that would have established this International Commission of Inquiry. One of the limitations with the international system is that the geopolitics of it very much reproduce domestic geopolitics. I don't know if you can use geopolitics in a domestic sense, but they very much reproduce the power distribution of the domestic. And so what we saw at the UN level was the US, Europe, Australia, essentially exerting the kind of pressure that meant that that resolution ultimately was not passed. And that was a blow to everybody who had been pushing for it. Instead, what we got was a resolution that authorizes the High Commissioner for Human Rights to produce a report on systemic racism in law enforcement. And so now we are in a process of trying to understand how different actors, including some of the movement actors that have been the most vibrant in the US, can feed into that process to ensure that there are ways of using international human rights law to supplement and augment what's going on domestically. There was a report that came out not that long ago that that did a study of 20 of the biggest police departments in the US, and showing that their use of force practices were completely out of line with international human rights standards, for example. And so I think within the human rights movement, we are hoping that this will be, even though we don't have the Commission of Inquiry, that this process that has been set up might nonetheless feed into, again, national and local efforts to close the gap between the domestic and the international standards. So unimaginably hopeful and wonderful things happen, but also really dark and terrifying things happened in this process as well.
Thank you. Thank you for sharing that. Joanna, I want to come back to you and ask for you to spell out a little bit more what your recommendation is vis-a-vis qualified immunity, and then also to reflect a little bit on what that would do and what it wouldn't do. What would be the value of those reforms and the limits?
Great, thank you. So my point of view is that we should eliminate qualified immunity, full stop. And I believe that is, I believe that the doctrine is not founded in history, and that the policy goals that are intended to be achieved by the doctrine aren't met. One of the goals is to shield officers from financial liability, and indemnification agreements mean that officers virtually never pay anything towards settlements and judgments entered against them. Another justification for qualified immunity is that it shields government officials from the costs and burdens of litigation. My research about the effects of qualified immunity and the impact during litigation is that it actually doesn't do a very good job of achieving those goals either. And in part, that's because there are so many other barriers to relief in these cases. And Devon, I wouldn't, just as Devon might not want to talk about qualified immunity, I don't know that I want to talk about the Fourth Amendment with Devon on the Zoom, because he has such valuable things to say about it. But the Fourth Amendment and the way in which it's constructed already shields government officers from so-called reasonable mistakes. And so to the extent that there is concern that, and sort of the talking points for those who defend qualified immunity are that officers will be inundated with frivolous suits, that they will not be protected for making good faith mistakes in the split-second nature of their work, and that they will be faced with bankruptcy if they do. And none of those justifications hold any empirical, have any empirical support. The Fourth Amendment already protects against reasonable mistakes. Frivolous claims are dismissed in many other ways through other legal vehicles in court, and officers virtually never pay. So that's my simple recommendation about what happens. There is a lot of debate about what impact eliminating qualified immunity would have. And in short, my view is that eliminating qualified immunity would encourage more lawyers to be willing to accept civil rights cases than currently are. It would reduce the cost and the risk and the time associated with bringing these cases. And so more cases would likely be filed and more lawyers would be willing to bring these cases. I think more cases would go to trial because of a reduction of those same risks, which means more transparency and more public airing about these cases. And I think that there would be more clarity about the scope of constitutional rights, because cases can be dismissed on qualified immunity grounds without courts ever ruling on the constitutionality of the underlying conduct. And so for all of those reasons, I think that there is great value in eliminating qualified immunity. In addition to the fact that there are people whose rights are violated who get no recourse, and that would change to the extent that qualified immunity is the reason the cases are being eliminated. I don't think that there would be an influx of frivolous cases because of the other barriers to relief. And I also don't think that eliminating qualified immunity is the silver bullet that people hope it might be. I think that there are still a lot of ways in which people, officers who have violated what we might think of as, certainly international norms and norms that we may hold dear, are nevertheless not have not violated the Constitution. I think that there are other aspects like indemnification arrangements, like union agreements, like city budgeting that still mean that lawsuits and misconduct have a muted impact on police departments and police officers. So I don't think that eliminating qualified immunity gets rid of any of those deeper problems, but I think it does some very important things. And for those reasons, I think that the doctrine should be eliminated.
Thank you. Devon, I want to turn to you now and ask, so we've just heard about two pretty concrete possibilities, an international commission of inquiry and creating a space to focus on accountability, and then some important but relatively defined doctrinal reform. Are there other legal or doctrinal reforms that you think could make a difference, but maybe a limited difference? And I say this as a prelude to then pivot toward, we're getting a number of questions about more transformational modification. But before we go there, I want to get your view on doctrinal reforms, legal reforms. Are there some that you think might make some positive difference? Or is that the wrong lens?
So I think I've tried to follow some of the questions being raised in chat as well. I think it's crucial that people that we say what people already understand, which is to say there is no sort of doctrinal fix per se. I mean, and it's also equally important to say that we're having a conversation about law. We could be having a conversation about political institutions or political reform, and recognize that there are limitations to what that site affords as well. To put all of this another way, there are multiple sites for social transformation. None should be ceded from my vantage point. One has to think about the limitations of all of them. It's not as though even when one is engaged in activism on the ground, so to speak, one is outside of the very regime that one is contested, trading on the Constitution for free speech rights, for example, to protest. So it's always a complicated relationship between an inside or an outside relationship to things that might be worrisome. With respect to law, I mean, part of what I've tried to highlight in my own scholarship is problems of police power. Problems of police power that are rooted in a particular history of policing in the country, by which I mean the quick move that we sometimes make when we're talking about policing is to assume that forms of policing with which we might disagree, forms of policing that we find troubling, or forms of policing that reside outside of the domain of constitutionality. That is an erroneous way of thinking about it. There's an awful lot of police activity that we might describe as violence, that we might find as worrisome vis-a-vis the overarching surveillance state that it produces, that is perfectly legal. And I think it's crucial then that it's another reason why the role cop, bad cop frame is not a useful one for thinking about the problem. We have to think instead about policing in relationship to other social structures that produce various forms of inequality. If I were to answer your question directly with respect to Fourth Amendment, there's so much wrong with that doctrine that I don't have time to articulate. I will simply say that it's supposed to function in a formalistic sense as a restraint on police authority, and it functions instead as a source of police power. And there are lots and lots of different ways in which that's the case. And so in some ways, Joanna has it exactly right when she says, giving up, when cops give up qualified immunity, it's not like they're giving up a lot. I mean, there's an awful lot of protections. We can think of the Fourth Amendment, and I'll stop here, as a privileges and immunity clause for police officers, straight up. That's a very easy way to understand it. I'm not going to go into details about how that works. Buy my book when it comes out. But seriously, I mean, it has turned out that over 4 to 5 decades, the Fourth Amendment as one site for the expression of police power has in many ways created pathways to precisely some of the violence that we are presently witnessing.
Thank you. That's very helpful. I want to try to draw together several questions from the Q&A, which are really about the sort of relationship between reform and bigger transformation, right? So we've got somebody who asks very specifically, how do we pursue reforms without thereby getting in the way of more transformational demands? We have somebody else who asks, about the tension between reforming police or accountability measures and approaches that are more to abolition or much bigger picture approaches. We have another person who says that law seems well suited to reform, but that maybe legal structures aren't so able to handle the bigger picture challenges, and that reform might even prop up rather than dismantling the core function of policing as a handmaiden to inequality, and especially the property haves versus have-nots that's part of racialized capitalism. And so I'd love to ask that this person, actually a law professor, asks in her question, what role, if any, can law play in a more radical and even revolutionary agenda? How do we think about this tension and this problem? So I'd love to invite each of you to reflect a little bit. Who wants to start?
I'll jump in quickly and leave the experts to then say things after I've spoken. So I think this is a question for which, again, the International Human Rights Framework has a lot to offer. And I'm somebody who's critical of that frame in many ways. It is by no means perfect. My scholarship maps some of my deep concerns with the framework. But as an initial matter, I think the International Human Rights Framework is helpful for reminding us that even though we're talking about the policing context, really what's the concern here is systemic racism. And by its very nature, it is not confined to one institution. We might talk about criminal justice more broadly, or we might just think about society. And I think at the international human rights level, the conventions start from or provide the means for really taking a structural approach that thinks about anti-racism broadly, and then from there you work backwards to what you do in the policing context. And when you talk about abolitionist or kind of more transformative approaches to thinking about systemic racism, I think one thing that's really powerful about this moment is those kinds of conversations are on the table, right? When Black Lives Matter says defund the police, this is no longer considered a sort of, what are you even talking about? We are taking seriously what it might mean to undo policing as the kind of structure that it is. And I want to connect that to the project of reparations, right? The reparations for historic injustice and contemporary injustice, for which at the international level, you have a much stronger blueprint, you know, for what that might mean more broadly. And then if you look at what movements are doing, I think they are giving us a blueprint for what it might mean to enact those projects kind of nationally and locally. So I would say that there is space for transformation and especially at the agenda setting level, if what we're looking at is undoing structures of systemic racism in the policing context, situating that in the context of broader systemic racism within the US, and then thinking about the kinds of step-by-step interventions that take us closer to undoing structures rather than fixing things that we think are entirely broken. So again, saying international system gives us resources, including legal and policy ones, even though they are not perfect, and also can help us think about how we navigate the concrete steps that are necessary in this space.
Thank you.
So I'll just build on those terrific comments, which make what I want to say not as hard as it might otherwise be. So it's just a couple of reactions to those terrific questions in the Q&A and in the chat. So let's pick up the point about abolitionism for a minute and focus for a moment on prison abolition, which has been a long-standing movement in this country that people have been deeply invested in. So people tend to understand these ideas in relatively simplistic and static fashions, whereas people who are engaged in the movement for these ideas understand them in a very nuanced way. So one could think about prison abolition as let's go down there tomorrow and tear down all the prisons. Now, clearly, that's an entailment of some of the arguments. But if we borrow a line from feminism that goes something like, women are not born women, they become women. That is to say, there are social processes that produce women. We might say, for example, that prisoners are not born women, they become, prisoners are not born prisoners, they become women. And then we ask ourselves, so what are the social processes? What are the pathways to that mass incarceration? Abolishing those pathways is a move to prison abolitionism. So in the same way, one can think about reform and abolition not as totally oppositional thing. It's complicated, so that one might think about particular moves. I don't know the move that you make tomorrow that isn't already replicating the thing you say you don't want. So it's really more a question of how do we think about the complex relationship between reformism and abolitionism. I don't presume to have a clear answer to that, but I want to frame the question in that way. A second thing I want to say is, and I've said this before and want to repeat it again, law is not the only site that carries with it profound limitations. But the law as it currently stands reflects the view, for example, that societal discrimination is quote unquote too amorphous to be constitutionally cognizable. Suppose law didn't articulate that position. Suppose law reflected the idea that societal discrimination is a matter of constitutional concern. That wouldn't change everything, but it would change something. Law currently reflects the idea that we look for intentional bad actors. Suppose law reflects the idea that disparate impact, qua disparate impact, full stop, gives a cognizable claim, it wouldn't solve the whole thing, but think of how many legal claims. Racial disparities traverse the US landscape. Think about all the interventions you could make if disparate impact, quad disparate impact was a cognizable claim. So I don't think we should poo-poo law on the one hand, nor do I think we should hold it up as the holy grail. And I don't think it's productive to think that abolitionism is over there and reformism is over there. I just think the interstitial space between the two is more complex, even as I can't articulate that complexity here and would want to learn from others about precisely how to do so.
Well, thank you. Thank you. That's very powerful. Joanna, anything to
Well,
to
you
add?
have both done the heavy lifting of making these points so beautifully, and I agree and sign on to everything that Tendayi and Devon have just said. And the only thing that I would add is that I feel that the debate around reform versus abolition, or defunding versus reform in the policing contexts, doesn't adequately map the nuance, as Devon said. And I fear that it ends up presenting this sort of zero-sum notion or choice one to the other, ends up taking power away from both, and taking energy into this debate about reform versus defunding or abolition, as opposed to recognizing and celebrating the ways in which they are connected one to the other.
And if I could say one more thing on this point, Jennifer, just to be clear. So I think we're in this moment clearly because people on the ground have been doing an awful lot for an awful lot of time. I don't see my role as standing in the way of that. So that's not, there are particular ways in which I understand how law works and the way in which law instantiates racial power, and I'm happy to describe that, and people can do with that what they want. I don't see it as my role to offer solutions when I know that people are doing that and that they're informed in ways that I'm continuing to learn from. So I don't want to stand in the way of any of that. And I know my particular lane, which is not a view that I'm articulating vis-a-vis how other scholars might occupy space. That's just how I conceive of my own role as a scholar in this particular domain. And the final thing I would say, the divest, invest, there's a reason why people often talk about divest, invest, because we recognize this is a moment when we're talking about policing. And as I think one question put it, we could be talking about structural violence in education. We could really be talking about that. And we have to remember that there are other sites where structural racism is playing itself out in very deep and profound ways that's not necessarily on our anti-racist table. And they're interconnected. So the reason we have a police contact problem, both because of the historical footprint of the police, but also because of a de-investment in particular communities and what that has produced with respect to vulnerability to the carceral state. So I don't think we can ignore that part of the puzzle in this conversation as well.
Thank you. No, I think that's important to sort of, this is one site among many, and some of the comments and questions are pointing that out too. So some of the comments and questions are taking this more theoretically, taking this in a more theoretical direction, and some in a more practical. And I want to make this concrete for a minute. We can kind of go dialectically between these levels and sort of ask. We have one person sort of saying, I want some specifics. We have some other people asking what law should activists target for revisions. If listeners are trying to figure out something to focus on to try to achieve some change, some positive movement, where would you direct them? What do you think? Where's there some concrete possibilities? And then we can also return and go more meta. But I want to ask the concrete question first. What would you? Joanna, you gave us a bit of an answer with qualified immunity, so maybe I'll start with Devon and Tendayi. Where would you draw people's attention?
Yeah, and I will take them in the direction of the international human rights questions. There was some saying, there's a question in there saying, what can US advocates or even lawyers do to help, with using the international system to promote accountability. So Devon was talking about the disparate impact, disparate racial impact as uncognizable as a violation under domestic law in different areas of life. Under international human rights law, that's required, right? So the definition of prohibited racial discrimination is not just about intent, it's also about effect. And I'll point out that the US was central in pushing for that articulation of the prohibition of of racial discrimination at the international level. So sometimes there's pushback to the international system from people who say, look, we're a sovereign nation, why should we be subject to that? I want to make clear that the very definitions at the international level are a product of a lot of US advocacy to get them to say what they are. And one of the criticisms from the body that is tasked with monitoring compliance with the treaty is that the US's domestic and federal legislative regime is out of whack. It's basically violating the standards to which the US has signed up to. So I see legislative reform and campaigns, that would, in a political climate that is conducive to this, that would just close even just that one gap would make a really, really big difference. I would say investing more deeply in understanding the levers that allow domestic advocates to get where they need to go using the US's existing obligations would make a really big difference.
Okay, and I'm going to make you be even one step more concrete. What would that investment look like? How could we begin to make that more possible?
I think it would mean putting it on the agenda of political parties, for example, and saying, look, if you really do believe that Black Lives Matter, what is your legislative pathway towards ensuring that the International Convention for the Elimination of Racial Discrimination is fully implemented in the US? And there are countries in the world that are implementing it in leaps and bounds in ways that make the US look like a leading human rights violator. So that would be a very concrete way of saying, do you really care about these issues?
Excellent, thank you. That's really helpful. Devon or Joanna, any thoughts?
So I'll just say very quickly, because again, I think that there are movement organizations that are offering a vision for how we might think about some of this. And as I said before, and I'll repeat here, I don't want to offer anything that gets in the way of those particular proposals. What I will say is two things. So one, I want to go back to the point I made about intentionality, because it's important to put this particular issue in sharp relief, not to fetishize again law as any particular vehicle. In the context of the case in which the Supreme Court refuses to adopt a disparate impact regime, the court does so on the view that to allow disparate impact would create a parade of horribles, the court basically says. That is to say, it would invalidate a whole range of social welfare programs, or a whole range of initiatives in which the state might be engaged. In other words, it's another moment in which the court is saying too much justice. So there's a recognition, and there's a recognition that to go this path will do some anti-racist work. So one thing we might do in that regard is to take the point Tendayi just made seriously and ask ourselves, governance happens at multiple levels, formal governance, whether it's city governance, state governance, et cetera. And historically, civil rights interventions have thought about links between, social movements and Supreme Court adjudication. But if we think about even how developments around LGBTQ have happened, it's not necessarily been Supreme Court. It's been more local and then up. And needless to say, we have a lot of work to be performed in that context. But nevertheless, cities began changing their regimes. States began changing their regimes, and the Supreme Court ultimately followed up. There's a way in which putting these questions on the table at the city level and at the state level, what is your conceptualization of discrimination? What kinds of claims can be cognizable or not, is one very concrete thing that we might do. We're about to have a conversation about Proposition 209 again, one that is completely disaggregated from this conversation, one in which people frame affirmative action as a racial preference or somehow as an elite project, failing to recognize you can literally look at the logics of race that get articulated in the affirmative action context and then gets exported to circumscribe voting rights regimes, to circumscribe so a lot is at stake with respect to other avenues in which race is working its way out. So concrete way to think about this, use these other levels of power. The Fourth Amendment, for example, it's not the ceiling, it's the floor. States can do better than that. What if, and then I'll stop here because I'm rambling. What if a state law regime said, you know, this is going to sound totally radical, you need a warrant to engage anyone, full stop. That would keep the police off the backs of Black people, certainly. Who the police are is a function of the power they have. In other words, we talk a lot about the social construction of this. The police is socially constructed as a function of a constellation of powers. Think about the ways in which those powers might be peeled back is a way of thinking about going forward as well.
Great, thank you. Joanna, I want to take this question to you, and I want to make it, I want to sharpen it even a little further. At the suggestion of one of the questioners, Gil Garcetti asks, what could be done, what do we frame it, what could be done immediately? Like what if listeners are looking for next steps, revising or adding to particular laws in the legislature, otherwise taking immediate next steps that go beyond the qualified immunity conversation we've already had, what do you recommend?
Absolutely, and I agree with Devon and take his point that we should be thinking at the state and local levels because there is a great deal of opportunity there. I would encourage you, anyone who is interested, to look at the bill that was recently passed in Colorado that created the ability to sue government officials for violations of the state constitution and eliminated qualified immunity as a defense to those claims, and also structure payouts and budgeting in really interesting ways that we don't have time to talk about here. But I think that the Colorado statute is a very interesting approach to think about. At the city level, I think that local, and this returns to the discussion about union agreements. Union agreements are recognized as impediments to reform. Those agreements and unions are blamed for those agreements, but those are contracts that are signed both by union officials and by local governments. Cities sign those, and so they're thinking about renegotiating and thinking about the terms of those agreements, requiring local law enforcement agencies to take a more proactive approach to gathering and analyzing information from those lawsuits and taking action to prevent future harms as a condition of indemnification, for example, is another approach. And I also think that the conversations that are beginning now need absolutely to continue, that happen at the local level, about what power we give law enforcement, what authority we want them to have. Do we want them to be our first level responders to mental health crises, to domestic problems, to car crashes? What do we want them to be doing? And how might we think about restructuring social services in our communities to better reflect those community goals and priorities? Those are things that can happen at the local level, and they really can happen quickly. They can happen through community advocacy. So local governments have a lot of opportunities to make those changes, and I think that state legislators do as well, as they did in Colorado.
Thank you. Devon, back to you for a quick, more structural response. If you think about some of the other actors, whether it's the police unions or prosecutors and defense attorneys, can some of the structural frames that you've been giving us help us understand that this is completely unfair because it's in 75 or 90 seconds. Can we broaden the frame of actors and think about that in some way?
I mean, I think it is an impossible question to answer. Because if I focus just on there are multiple institutions that are engaging in practices every day that are implicated in the problems that we might want to address. I mean, we've said nothing about COVID in this particular moment, but we could think about the relationship between healthcare and vulnerability to the virus. I do want to, so I want to actually go a little more granular, because I know that there's been a set of comments around specificities, and there have been some specific things that have been put out there. I mean, again,
very much so.
Just on the level of legal transformation, if qualified immunity is abolished, that's if the intent standard is abolished, if you have disparate impact, if you have a regime at the state level around the equivalent of Fourth Amendment that isn't the Fourth Amendment. I mean, all of these are doctrinal regimes, and they're not abstract. They're very material and concrete, and that could do a lot of work. Now, how you get law reform is how you get law reform. That's not something that we can unpack in this particular session, but we've certainly identified some sites that are relevant to that particular project that I wanted to at least remind people before we check out.
That's fabulous. That's really helpful. Tendayi, I'm going to give you the last word. A couple of people have asked, would it make a difference for these human rights regimes at the international level in this space if Biden won in November? You know, obviously a different politics, but also at the national level, some ongoing, you know, self-protection by the United States. Do you think that would make very much difference in the conversations that you'd be part of?
So two quick things I want to say, one directly in response and one not. So it depends, you know, both the Democratic and Republican administrations have been resistant to complying with international human rights law. And I think it will depend on the kind of pressure that would be put on the Biden administration, if that's where we go, to actually close these gaps. And so the American exceptionalism that brings us to this moment where the US is so far out of step with the international could persist irrespective of who we have in that role. But these kinds of conversations, I think, make it more likely that these ideas will be priorities and on the agenda. And then one final thing I'll say on kind of immediate next steps. It strikes me that listening is not something that lawyers are really good at. And when we listen as lawyers, there's there's constituencies we listen to and others that we don't think are relevant for the production of legal knowledge, for production around litigation strategy, you know, how you organize your office as a lawyer. And I would say this moment is showing us that we need to be listening to different sources. Right here in Los Angeles, for the audience members who are here, there are movements and community-based organizations that have done experiential studies of our police departments and are making very concrete, immediate demands about what can happen in an hour. But the question is, are lawyers listening? And so I would say the first thing that is urgent is change who you're listening and ensure that the people who you're listening to actually have those blueprints, because they're out there. They really, really are. So that's what I'll say to end.
Thank you. That's a terrific point on which to end. I am incredibly grateful to my three fabulous colleagues and panelists, and to all of you for listening in and for asking terrific questions. I'm sorry we couldn't get to all of them, but we will follow up with a few. Some of you asked specific questions about literatures and information, and our follow-up email will provide some of that. So thanks so much for joining us. Obviously, much more that could be said, but we really appreciate you spending this hour with us. And thanks to my panelists. Take care.
Thank you for having us.